Within Chapter 9, we'll be discussing the legal pitfalls of discipline, terminations, and layoffs. Once completed with this chapter, you should be able to define due process and apply the concepts of due process to common situations encountered during employment investigations in EMS organizations, describe the concept of retaliation and review best practices to minimize the risk of a retaliation claim, define the Worker Adjustment and Retraining Notification Act, and define its purpose and compliance requirements. Identify the importance of adequate policy manuals and be able to apply the concepts to several scenarios within an EMS organization. Explain the employment at will legal doctrine that applies in many states and its effect on EMS personnel issues. Discuss right-to-work statutes that apply in some jurisdictions and how these laws affect EMS personnel issues. And analyze the issues associated with severance and layoffs and form conclusions with best practices for an EMS organization. This may seem like a somewhat odd scenario for an EMS provider, but imagine for a moment that you show up at work one morning to find a sign on the door stating the business is closed and no longer in operation due to bankruptcy. You are unable to find anyone to answer your questions, and all phones have either been disconnected or are not being answered. So what would you do? What are the next steps you should take? Would it make a difference if you are an at-will employee as opposed to a contract employee? Interestingly enough, many employers who have at-will employees are under the mistaken impression that they can abruptly fire anyone they choose for any reason, but this is not always true. If a termination of an employee is not performed correctly, it can have legal ramifications that could range anywhere from reinstatement of the employee with back pay to a large financial settlement for wrongful termination. To begin, it is important to recognize that all employees have a certain amount of due process rights that must be afforded to them in employment actions. The threshold as to what the due process requirements are can vary somewhat from employer to employer, particularly when comparing a governmental employer to a private one. In general, though, processes and procedures related to investigations and possible terminations, suspensions, or demotions of employees must be followed in all instances to protect both the rights of the employees as well as the interests of the employer. If established policies are not legally defensible or are not followed, the employee or former employee may have grounds to sue the organization based on errors that occurred in the investigation and termination, suspension, or demotion process. If the employer is a private employer, those claims typically must be based upon some type of bad faith action, such as a demotion due to a discriminatory reason or a termination in violation of a law. Public employees, on the other hand, have greater due process rights, and even if the termination or negative employment action is warranted, a failure to provide adequate due process could give rise to an employee lawsuit or other challenge. For the remaining discussion on this topic, we will deal specifically with governmental public employers. Unless there is a law stipulating otherwise, private employers have much more latitude in the discipline and termination of employees so long as the negative employment action is not in bad faith or in violation of a law. Assuming an employee has passed his or her probationary period, the employee has a right to a fair hearing when facing termination. Components of such a fair hearing include providing adequate advance notice to the employee that he or she may be suspended, terminated, or otherwise disciplined. The employee must then have an opportunity to address the employer's concerns at a hearing. These public employee due process rights are founded in constitutional protections within the 5th and 14th Amendments. When evaluating an employment action due process claim, the Supreme Court identified 3 factors to consider: the private interest that will be affected by the official action, the risk of an erroneous deprivation of such interest through the procedures used, and the government's interest. With these factors in mind, in order to bring maximum fairness, protect the employee's constitutional rights, and prevent the possibility of a lawsuit, there should be a complete investigation of the charges or allegations against the employee, along with notice to the employee of the proposed action and the grounds that form the foundation for that action. The employee must be given an opportunity to present reasons why the proposed action should not be taken, and both parties, the employer and employee, should have the opportunity to present evidence to support their respective cases, which may include the need to call witnesses to testify. Ultimately, the final decision to suspend, demote, or terminate the public employee must be based exclusively on the evidence presented. Basing negative employment action decisions on anything other than objective findings can give rise to viable legal challenges on behalf of the employee. In many environments involving a public employer and protective service employees, it is not unusual for the employment relationship to be governed by a collective bargaining agreement, assuming the employees are unionized. In the absence of such a document, public employers should maintain an employee handbook or manual to outline expectations, policies, processes, and procedures related to the employment relationship. It is important to draft the handbook or manual in such a fashion that it does not constitute a binding contract between the employer and the employees. Otherwise, this employer-generated document could potentially be used against the employer in litigation to show the employee had a contractual right to something contained within the manual or handbook. For that reason, many employee handbooks or manuals expressly state that the document is not to be considered an employment contract. Additional due process rights afforded to public employees are Weingarten rights, Garrity rights, and Loudermill hearings. The employer need not provide notice of an employee's Weingarten or Garrity rights. As a matter of practice, however, many provide the notice in writing just to make sure there is no confusion later as to whether or not the employee either exercised or did not exercise those rights. The burden of proof in the case is not related to these rights, as the employer must still shoulder the burden of proof when investigating employees for misconduct. Under Weingarten, a union employee facing potential discipline has the right of union representation during any investigatory meetings. To exercise his or her Weingarten rights, the employee must request union representation before or during the interview. Representation cannot be requested retroactively. Once the employee invokes his or her Weingarten rights, the employer must delay the interview until a union representative is present. Continuing with the interview without such representation for the employee may constitute an unfair labor practice. Additionally, the employer cannot discipline the employee for refusing to answer questions without a union representative present. Garrity rights exist to protect public employees from a catch-22 situation in which an employer orders the employee to answer a question during a disciplinary investigation with potential criminal prosecution implications under threat of further discipline or termination for failing to comply with a direct order. In that situation, the employee then has to decide whether to answer and potentially provide self-incriminating evidence against him or herself despite Fifth Amendment protections to the contrary, or to not answer and face termination. Garrity is especially important if the alleged employee wrongdoing could be criminal in nature. Once an employee exercises his or her Garrity rights, the public employer must now decide which direction to take the investigation. The employer can still order the employee to answer the questions, but the government then waives the ability to prosecute the individual based upon any information derived during the interview. An attempt to prosecute can still occur, but the statements made by the employee cannot be used as evidence within the case. Inversely, the employer can end the interview and proceed with the investigation without conducting an interview of the employee. Before the employer can discipline an employee for refusing to answer questions, the employer must complete the following: order the employee to answer questions under threat of disciplinary action. Ask the questions that are specifically, directly, and narrowly related to the employee or his or her fitness for duty, and advise the employee that the answers will not be used against him or her in criminal proceedings. If the employee still continues to refuse to answer the questions, the employee may be disciplined for insubordination. Keep in mind, however, that Garrity protections apply only to potential criminal prosecution. Statements made under Garrity can still be used for disciplinary proceedings, civil cases, or proceedings against another employee. If the employee chooses to give a voluntary statement, it can be used in subsequent criminal prosecution. Lastly, if a public employee is facing potential suspension or termination, the employee has the right under Loudermill to a hearing where the employee can provide additional evidence before the disciplinary action is decided. Under Loudermill, the employee has the right to receive notice of the hearing and also has the right to be heard at the hearing. When discussing employee rights, it is also important to note that laws exist to protect employees from employer retaliation for asserting or exercising their rights. Retaliation occurs when an employer takes an adverse employment action against an employee because he or she filed a charge or claim against the employer or a fellow employee. Many of the laws in place to protect workers from retaliation are referred to as whistleblower laws, which were designed to protect employees from employer retaliation for reporting illegal or other bad conduct on the part of the employer or another employee. For instance, if an employee files a claim or complaint of discrimination, employer retaliation against the employee is illegal. For an employee to claim he or she suffered from retaliation, the employee must show he or she was engaged in a protected activity, such as reporting employer wrongdoing to the authorities. There was an adverse employment action by the employer against the employee, and there was a causal connection between the employee's actions and the subsequent adverse employment action. Believe it or not, a claim for retaliation can go beyond the date of employment. An example would be an employer who gives an employment reference in bad faith. Anti-discrimination laws also provide additional protections for employees beyond traditional whistleblower protections. From a logistical perspective, singling out an employee for adverse action because he or she filed a claim of discrimination is very disruptive to the workplace, and the retaliation may impact productivity from more than just the targeted employee. If a discrimination claim is made, the best employer action is no action against the employee who filed the charges or complaint. Rather, the employer should try to seek a common ground with the employee to determine the nature of the grievance and develop some type of common ground upon which to resolve the issue that gave rise to the complaint. To help address such a potential situation, employers should have policies in place to prevent discrimination in the workplace, and training should be provided to assist personnel in knowing how to prevent discrimination issues in the first place. Supervisors in particular should be educated as to what defines discriminatory behavior and ways to minimize such behavior. If an employee does file a claim against the employer, whether it is discrimination related or some other issue, the employer should communicate the no retaliation rule to the employee and should also attempt to keep the interview confidential so as to minimize the potential for those not involved in the investigation from contributing to any illegal retaliatory conduct. If at all possible, individuals involved in deciding the employee's status in the future should not be made aware of previous complaints or allegations. This would hopefully insulate them from knowledge that could serve as a basis for retaliatory conduct. Trying to limit the spread of information to only essential parties is important, as gossip about the investigation can develop into retaliation claims, which can damage reputations of those involved in the case even before an outcome is reached, as well as impact productivity and employee morale. Rumors or discussions about the investigation could also impact future discussions with other employees. If a person files a complaint, there may be scenarios in which temporary measures may be prudent to protect the organization and the employee. The employer must be wary of such steps that could have a negative impact on the employee, however, such as administrative time off either with or without pay. Having a policy in place and following that policy in all cases is important to help avoid claims of retaliation. If the charge or complaint relates directly to another employee, the employer may want to split the accuser and accused so they do not work in the same station or on the same shift. An attempt to limit contact between the two may be prudent, although it is important to not disadvantage or disparage the accuser if such steps are taken, as it could be considered a type of retaliation. It probably goes without saying that employers should exercise caution when disciplining or terminating an individual who has alleged an unlawful employment practice. Employees cannot insulate themselves from negative employment action by simply making a complaint against their employer, but the circumstances involved could complicate such negative employment actions, so employers must be wary and follow their policies and procedures very closely. If other employees previously engaged in similar conduct as the employee currently in question, they should have received comparable levels of discipline. Consistency in the application of such discipline is important. Trying to maintain a positive work environment based upon open communication and mutual respect is important to help prevent discrimination and retaliation claims. By working together, it can be possible to diffuse volatile situations before they detonate, so to speak. Shifting gears from discipline and retaliation, we will now look at outright terminations and layoffs with a discussion of the Worker Adjustment and Retraining Notification Act of 1988. The WARN Act requires most employers with 100 or more employees to provide at least 60 calendar days notice of plant closings or mass layoffs of 50 or more employees at a single site. This notice must be provided to managers, supervisors, hourly wage earners, and salarized workers. If there is an employees union, it must be notified as well, in addition to the local chief elected official and the state dislocated worker unit. This advance notice is mandated so that employees and their families have some time to adjust to the prospective loss of employment and strategize their next steps. It is important to note that governmental entities that provide public services are not covered by the WARN Act. In addition to the WARN Act, Wisconsin also has its own business closing and mass layoff law, codified in Chapter 109.07 and DWD 279. The criteria in Wisconsin's law are somewhat different than the federal law, covering employers with 50 or more employees who wind up laying off 25 or more employees at a single worksite, or make a reduction in the workforce that impacts at least 25% of the workforce of 25 employees or at least 500 employees for very large employers. If the layoff falls under the requirements of both WARN and the Wisconsin law, then the provisions of both laws must be followed. As far as EMS agencies are concerned, the WARN law does not impact governmental fire and EMS services. WARN was designed to protect those employed within the private sector. Wisconsin's law also does not apply to governmental agencies. Thus, unless a private EMS agency meets the minimum threshold for employees under either the federal or Wisconsin laws, no notices are issued. While discussed very briefly earlier, the importance of adequate policy manuals and handbooks will now take center stage. Employers have policies to dictate employee behavior or guide the employer in certain actions. The policies communicate expectations to everyone involved in the organization. Some very essential policies are actually dictated by federal or state law in areas of discrimination, workplace harassment, driver's license requirements, and other personnel matters. As mentioned previously, though, the policy manual or handbook should clearly state the document is not an employment contract, especially if the organization has at-will employees. While a collective bargaining agreement may cover contractual obligations of the employer and employees with regard to some of the following topics, that still does not mean the employer should not have policies covering equal employment and non-discrimination laws, family medical leave policies, workers' compensation guidelines, provisions regarding time off, including vacation and/or sick time, pay, promotions, other benefits, employment expectations, including employee behavior, progressive discipline, appeals or grievance processes, use of social media and photography, maternity and paternity leave provisions, light duty if available for both on-duty or off-duty injuries, anti-bullying, anti-harassment, health, wellness, safety, computer monitoring, technology use, email usage, smoking or tobacco use, whistleblowing protection, and anti-retaliation provisions. As noted on the slide, employee manuals must be comprehensive. The employees must have ample access to them, and it is vital that everyone understands their responsibilities under the provisions within the manual. If a collective bargaining agreement exists, the manual and collective bargaining agreement should complement each other. Conflicts between the two documents could raise some significant problems. The previously suggested subjects to be included in an employment manual or handbook is by no means exhaustive or all-inclusive. The specific policies related to each subject are also unique to each organization. For instance, what one agency allows within its acceptable use policy, referring to technology, computers, and other electronic devices, may not be acceptable for another employer. As a result, this presentation does not delve too deeply beyond simply mentioning some of the subjects that should be covered. If you are responsible for creating or maintaining an employee manual or handbook, it is strongly suggested that you work with a labor law attorney or human resources professional to ensure your policies are adequate, clear, and legal. In private, non-unionized businesses, employees are typically considered to be at-will employees, meaning they are working at the will of the employer. From an employee perspective, this means the employee does not have any expectation of continued employment that would give rise to a due process property right in that continued employment. So long as a termination is not discriminatory, in bad faith, or otherwise illegal, at-will employees can be fired without any notice, reason, or recourse. With that being said, case law regarding at-will employees has evolved over time to provide at least some moderate protection for employees against the harsh consequences of a termination. These exceptions to the at-will presumption include public policy, implied contract, and implied covenant of good faith. Under the public policy exception to employment at will, a court may find a termination against public policy under certain circumstances. The most common example is in the case of retaliation, as it is against public policy. It is bad for society if an employee can be fired for reporting the wrongdoing of his or her employer to the proper authorities. Even if a statutory remedy is available, some courts have refused to recognize a separate public policy tort, meaning the statute is applied very narrowly and a wrongfully terminated employee under the public policy exception has very little recourse beyond what is defined within that statute. Additionally, the majority of states rely on statutory or state constitutional language to define its public policy exception to the employment at will presumption. As a result, this exception is not applied very broadly or often. A nationwide authority on legal topics, the American Law Institute, has proposed 4 protection categories within the public policy exception to employment at will. These include when an employer refuses to perform an act that is prohibited by law, reports a violation of the law, engages in acts that are in the public interest, or exercises a statutory right, such as filing a claim under the state's workers' compensation law. While the restatement is not recognized as law, many courts use the restatement for guidance, and some jurisdictions adopt language from the restatement into law. Whether the restatement is utilized within your state or not, these 4 exceptions are obviously very narrow and probably would not apply in most employee termination cases. One of the reasons it has been mentioned multiple times within this presentation that employers should be certain their employee handbooks and manuals explicitly state they are not employment contracts is because of the implied contract exception to the employment at will doctrine. If an employee handbook or manual contains statements related to assurances of job security or longevity, it could give rise to a reasonable expectation of continued employment. Even statements made by supervisors could give rise to an implied contract with some type of job security or longevity expectations. Again, employers can protect themselves by ensuring there is clear and unambiguous language within the employee handbook or manual indicating its policies and procedures do not create contractual rights. There is also something in the law known as the statute of frauds, which requires contracts for performance that exceed a year to be in writing. If a state has a similar law, that could help mitigate the proverbial damage created by an implied oral contract. If an employer has to rely on the statute of frauds to avoid liability for an employment action, however, the employer is probably in a rather unfavorable legal position to begin with. It would be best to avoid this potential complication entirely by ensuring all pertinent documentation is clear as to its purpose, including the recognition that the policy or provision does not create a contract between the employer and the employee. Some states also recognize an implied covenant of good faith and fair dealing in employment relationships. Such laws can fluctuate greatly from jurisdiction to jurisdiction, with one requiring just cause for a termination and another allowing a termination without just cause so long as it was not made in bad faith or was motivated by malice. Proving bad faith or malice can be very difficult as the evidence provided must establish the mental state of the employer. As a result, employers have rarely been found liable under an implied covenant of good faith and fair dealing. Beyond these recognized exceptions to the employment at will presumption, at-will employees may also bring claims against their employers for intentional interference with a contract, intentional infliction of emotional distress, and promissory estoppel. As these claims are not very common, they will not be covered in any further depth here. Additional information on these actions is available within your textbook. In 1935, Congress passed the National Labor Relations Act, which, among other things, created the first right-to-work law. Essentially, right-to-work laws recognize the right of an individual to work without joining or supporting a union by prohibiting union security agreements between the employees and labor unions as a condition of employment. Under this type of legislation, employees cannot be compelled to pay union fees or dues even if they are covered under a union contract. According to the textbook author, there were 24 states with right-to-work legislation in place before Wisconsin adopted Act 1 in 2015, which changed Chapter 111 to read that employees have the right to refrain from self-organization, forming, joining, or assisting labor organizations, bargaining collectively through representatives, or engaging in activities for the purpose of collective bargaining or other mutual aid or protection. Before the NLRA, employers could exist under a union shop provision that required all new employees to join the union after a minimum period of time after hire. After the NLRA, that practice was now illegal. On the other side of the spectrum is the open shop rule, under which an employee cannot be compelled to join or pay the equivalent of dues to a union. The employee also cannot be fired if he or she joins a union. That is essentially the impetus of right-to-work legislation. The employee has a right to decide whether or not to participate in a union. Generally speaking, EMS providers employed by private agencies are considered at-will employees and can be terminated for any reason unless those reasons are illegal, which includes discriminatory conduct. Regardless of whether or not the Warren Act or the Wisconsin equivalent apply to a pending layoff, it is still good practice for employers to notify employees in writing of impending layoffs, how many will be laid off, and what the time frame is for the layoffs. The more notice the employer can give, the better, as it gives employees time to readjust and potentially obtain replacement employment. In lieu of mass layoffs, many larger employers provide a structured reduction in staffing by either offering early retirement or a generous severance package to entice employees to leave early. That is not necessarily an option for the public sector employees, especially if a formalized pension system covers the employees. It is not unusual for unionized employers to have a clause in the labor contract that defines how layoffs are handled and who will be laid off first or last. Such systems are typically based upon seniority, providing greater job protection for those with more seniority. Dislocated workers may be provided health insurance continuation benefits under the Consolidated Omnibus Budget Reconciliation Act, which gives the former employee the right to temporary continuation of health coverage at group rates. COBRA applies to government employers and private employers with 20 or more employees. To qualify for COBRA benefits, the employee must have been enrolled in a prior employer-sponsored health insurance plan, and the severance from employment or reduction in hours must be due to a qualifying event, essentially any termination that is not a result of gross misconduct. After the qualifying event, the employer must notify plan administrators within 30 days. The individual then has 60 days to decide whether to elect COBRA continuation coverage and 45 days after electing coverage to pay the initial premium. COBRA does not require the employer to continue paying toward the former employee's premium, so COBRA coverage is typically more expensive for the terminated employee than when they were employed. In addition to providing notice of a layoff, it is a best practice for employers to also assist impacted employees with a job search, as well as providing notice of the availability of COBRA coverage. Going back to the scenario at the start of this presentation in which your employer simply closed its doors one day, if you are a contract employee, the employer must fulfill the obligations contained within the contract. At-will employees have less guarantees beyond being paid for time already worked. If unpaid wages and benefits are an issue, the employee should contact the state's Wage and Hour Division in the Department of Labor and Industries to file a complaint. Unfortunately, the employee may need to contact an attorney to assist in the recovery of those wages. The former employee should also apply for unemployment insurance benefits while looking for a new job. In summary, every EMS agency must follow due process rules, regulations, and laws designed to protect an employee's rights. Public employees do have broader due process protections than private employees. The importance of having a current policy manual or handbook cannot be overstated, as it can be utilized by the employer to guide the process by which employees are coached, disciplined, demoted, or terminated. So long as the reason for termination is not discriminatory or otherwise illegal, at-will employees can be terminated for virtually any reason. Employees under a labor agreement typically have more protections against hasty termination actions. In right-to-work states, there is no work rule that requires an employee to join a union or even pay fair share dues. Employers should have a discipline policy that addresses the issue of retaliation against an employee who files a complaint. Retaliation should be prohibited. Keep in mind as well that employers reducing their workforce still have obligations to their soon-to-be laid-off employees, such as payment of their final check, payment for unused earned benefits, and the possibility of COBRA medical coverage.